Well, now I would like to discuss about the Article 5, which concern permanent establishment. The first paragraph says, for the purposes of this convention, the term permanent establishment means a fixed place or business through which the business of an enterprise is wholly or partly carried on. The main use of the concept of a permanent establishment is to determine the right of a contracting state to tax the profits of an enterprise of the other contracting state. Preliminary observations. Under Article 7, a contracting state cannot tax the profits of an enterprise of the other contracting state unless it carries on its business through a permanent establishment situated therein. In many states, like Italy, for example, a foreign enterprise may be allowed or required to register for the purposes of a value-added tax or goods and services tax, VAT or GST, regardless of whether it has in that state a fixed place of business through which its business is wholly or partly carried on, or whether it is deemed to have a permanent establishment in that state under paragraph 5 of Article 5. By itself, treatment under VAT GST is irrelevant for the purposes of the interpretation and application of the definition of permanent establishment in the Convention. Paragraph 1 gives a general definition of the term permanent establishment, like a distinct site or a fixed place of business, i.e. a facility, that must be established at a distinct place with a certain degree of permanence, through which the business of an enterprise is wholly or partly carried on. This means usually that person who, in one way or another, are dependent on the enterprise, for example, personnel, conduct the business of the enterprise in the state in which the fixed place is situated. The term place of business covers any premises, facilities, or installations used for carrying on the business of the enterprise, whether or not they are used exclusively for that purpose. The mere fact that an enterprise has a certain amount of space at its constant disposal, which is used for business activities, is sufficient to constitute a place of business. No formal legal right to use that place is therefore required, but the enterprise should have the effective power to use a location, as well as the extent of the presence of the enterprise at the location and the activities that it performs there. So, if a location is at the disposal of the enterprise, it could be a permanent establishment. For example, an enterprise has an exclusive legal right to use a particular location, which is used only for carrying on the enterprise's own business activities, where it has legal possession of that location. Another example is where an enterprise is allowed to use a specific location that belongs to another enterprise or that is used by a number of enterprises and perform its business activity at that location on a continuous basis during an extended period of time. A location is not at the disposal of the enterprise, so it is not a permanent establishment. For example, an enterprise does not have a right to be present at a location and in fact doesn't use the location itself because the plant is owned and used exclusively by a supplier or contract manufacturer, and the enterprise receives the goods produced at that plant merely because all these goods is used in the business of that enterprise. The enterprise's presence at the location is intermittent or incidental, where employees of an enterprise have access to the premises of associated enterprises, which they often visit, but without working in these premises for an extended period of time. The first example: a salesman who regularly visits a major customer to take orders and meets the purchasing director in his office to do so. The customer's premises are not at the disposal of the enterprise for which the salesman is working, and therefore do not constitute a place of business for which the business of that enterprise is carried on. The second example is the following. A road transportation enterprise uses a delivery dock at a customer's warehouse every day for a number of years for the purpose of delivering goods purchased by that customer. The presence of the road transportation enterprise at the delivery dock would be so limited that that enterprise could not consider that place as being at its disposal so as to constitute a permanent establishment of that enterprise. The third example is the following. An employee of a company for a long period of time is allowed to use an office in the headquarters of another company, for instance, a newly acquired subsidiary, in order to ensure that the latter company complies with its obligation under contracts concluded with the former company. The employee is carrying on activity related to the business of the former company, and the office that is at his disposal at the headquarters of the other company will constitute a permanent establishment of his employer, provided that the office is at his disposal for a sufficiently long period of time so as to constitute a fixed place of business, and the activities that are performed that go beyond the activities referred to in paragraph 4 of Article 5. The second paragraph of Article 5 says that the term permanent establishment includes especially a place of management, a branch, an office, a factory, a workshop, and a mine, an oil or gas well, a quarry, or any other place of extraction of natural resources. This paragraph 2 contains a list, by no means exhaustive, of examples of places of business, each of which can be regarded as constituting a permanent establishment under paragraph 1, provided that it meets the requirements of that paragraph. The first paragraph says that a building site or construction or installation project constitutes a permanent establishment only if it lasts more than 12 months. The paragraph 3 provides expressly that a building site or construction or installation project, this term includes also the construction of roads, bridges, or canal, the renovation of them, constitutes a permanent establishment only if it lasts more than 12 months. Any or those item which does not meet this condition does not of itself constitute a permanent establishment, even if there is within it an installation. The 12-month test applies to each individual site or project. The paragraph 4 lists a number of business activities which are treated as exemption to the general definition laid down in paragraph 1, and which, when carried on through fixed places of business, are not sufficient for these places to constitute permanent establishment. The provisions of the paragraph actually amount to a general restriction of the scope of the definition of permanent establishment. The final part of the paragraph provides that these exemptions only apply if the least activity have a preparatory or auxiliary character. The purpose of paragraph 4.1 is to prevent an enterprise or a group of closely related enterprises from fragmenting a cohesive business operation into several small operations in order to argue that each is merely engaged in a preparatory or auxiliary activity. Under paragraph 4.1, the exemptions provided for by paragraph 4 don't apply to a place of business that would otherwise constitute a permanent establishment where the activity carried on at that place, and other activities of the same enterprise or of closely related enterprises exercised at that place or at another place in the same state constitute complementary functions that are part of a cohesive business operation. An example: Alpha is a company resident of State A and it manufactures and sells appliances. Beta, a resident of State B that is a wholly owned subsidiary of Alpha, owns a store where it sells appliances that it acquires from Alpha. Alpha also owns a small warehouse in State B, where it stores a few large items that are identical to some of those displayed in the store owned by Beta. When a customer buys such a large item from Beta, Beta employees go to the warehouse where they take possession of the item before delivering it to the customer. The ownership of the item is only acquired by Beta from Alpha when the item leaves the warehouse. In this case, paragraph 4.1 prevents the application of the exemptions of paragraph 4 to the warehouse, and it will not be necessary, therefore, to determine whether paragraph 4, in particular subparagraph A thereof, applies to the warehouse. The condition for the in this case, the condition for the application of paragraph 4.1 are met because alpha and beta are closely related enterprises. Beta stores constitutes a permanent establishment of beta. You have to consider that the definition of permanent establishment is not limited to situation where a resident of one contracting state uses or maintains a fixed place of business in the other state. It applies equally where an enterprise of one state uses or maintains a fixed place of business in that same state. The business activities carried on by alpha at its warehouse and by beta at its store constitute complementary function that are part of a cohesive business operation, that is storing goods in one place for the purpose of delivering that is storing goods in one place for the purpose of delivering these goods as part of the obligation resulting from the sale of these goods through another place in the same state. Under paragraph 5, it is a generally accepted principle that an enterprise should be treated as having a permanent establishment in a state if there is, under certain conditions, a person acting for it, even though the enterprise may not have a fixed place of business in that state, within the meaning of paragraphs 1 and 2. These provisions intend to give that state the right to tax in such cases. Persons whose activities may create a permanent establishment for the enterprise are persons, whether or not employees of the enterprise, who act on behalf of the enterprise and are not doing so in the course of carrying on a business as an independent agent falling under paragraph 6. Such persons may be hired individuals or companies and need not be resident of, nor have a place of business in, the state in which they act for the enterprise. Under paragraph 6, where an enterprise of a contracting state carries on business dealings through an independent agent, carry on business as such, it cannot be taxed in other contracting states in respect of those dealings if the agent is acting in the ordinary course of that business. The activities of such an agent, who represents a separate independent enterprise, should not result in the finding of a permanent establishment of the foreign enterprise. Under paragraph 7, it is generally accepted that the existence of a subsidiary company does not, of itself, constitute that subsidiary company a permanent establishment of its parent company. This follows from the principle that, for the purpose of taxation, such a subsidiary company constitutes an independent legal entity. Even the fact that the trade or business carried on by the subsidiary company is managed by the parent company doesn't constitute the subsidiary company a permanent establishment of the parent company. The same principles apply to any company forming part of a multinational group, so that such a company may be found to have a permanent establishment in a state where it has at its disposal and uses premises belonging to another company of the group, or if the former company is deemed to have a permanent establishment under paragraph 5 of the Article 5. Example. A company is a member of a multinational group and it provides services, for example, management services, to another company of the group as part of its own business carry on in premises that are not those of that other company and using its own personnel. The place where those services are provided is not at the disposal of the latter company, and it is not the business of that company that is carried on through that place. The fact that a company's own activities at a given location may provide an economic benefit to the business of another company doesn't mean that the latter company carry on its business through that location. So that place cannot be considered to be a permanent establishment of the company to which the services are provided. Paragraph 8 explains the meaning of the concept of a person or enterprises closely related to enterprise for the purposes of the article, and in particular of paragraph 4.1 and 6. That concept is to be distinguished for the concept of associated enterprises, which is used for the purposes of Article 9. It provides that a person or enterprise is closely related to an enterprise if, based on all the relevant facts and circumstances, one has control of the other or both are under the control of the same persons or enterprises. This general rule would cover also situations where a person or enterprise controls an enterprise by virtue of a special arrangement that allows that person or enterprise to exercise rights that are similar to those that it would hold if it is possessed directly or indirectly more than 50% of the beneficial interest in the enterprise. The taxation of services. The combined effect of Article 5 and Article 7 is that the profits from services performed in the territory of a contracting state by an enterprise of the other contracting states are not taxable in the first mentioned state if they are not attributable to a permanent establishment situated therein. These profits are only taxable in the other states. Something about electronic commerce. There are some discussion as to whether the mere use in electronic commerce operation of computer equipment in a country could constitute a permanent establishment. Whilst a location where automated equipment is operated by enterprise may constitute a permanent establishment in the country where it is situated, a distinction to be made between computer equipment, which may be set up a location so as to constitute a permanent establishment under certain circumstances, and the data and software which is used by or stored on that equipment, for instance, an internet website. The distinction between a website and the server on which the website is stored and used is important since the enterprise that operates the server may be different from the enterprise that carry on business through the website. Something about Article 6, which concerns income from immovable property. Paragraph 1 gives the right to tax income from immovable property to the state of source, that is, the state in which the property producing such income is situated. This is due to the fact that there is always a very close economic connection between the source of this income and the state of source. Article 6 deals only with income which a resident of a contracting state derives from immovable property situated in the other contracting state, defining the concept of immovable property by reference to the law of the state in which the property is situated, as provided in paragraph 2, will help to avoid difficulties of interpretation over the question whether an asset or a right is to be regarded as immovable property or not. The paragraph, however, specifically mentions the assets and rights which must always be regarded as immovable property. I think it's enough for this part of my report.